in many ways, there's like a 7-2 dynamic of the court right now, which is you have two justices in Thomas and Alito who I think predictably and reliably will rule on a series of things in ways that are predictable and reliable in terms of executive authority, in terms of their version of strict constructionism, whether or not they're actually strict constructionists, I guess is a highly debated topic. And then the other seven are both unpredictable, maybe not the three liberal justices, but certainly the four others are far more nuanced, moderate, unpredictable, not easily slotted into some neat paradigm of left, right, MAGA, liberal, progressive, you name it, in a way that is unfamiliar to people who want really easy binaries, like they're left wing, they're right wing, they're Republican, they're Democrat. And I've certainly been struck over the past 6 months by how variegated these coalitions seem to be. Much, I think, to the chagrin of those who thought you could just, a la the Federalist Society, just like pack the court, create a series of nominees and boom, you have insta alignment and rubber stamping. And no matter what you think about the Supreme Court, it certainly isn't doing that.
Oh, that's very true, and you put it very well, and it's complicated. At the National Constitution Center, we always urge learners of all ages to learn the methodologies of constitutional interpretation: textualism, originalism, pragmatism, natural law, precedent-based theories. Starting in middle school, I always love on the Zooms, I always encourage people to read the majority opinions and the dissents and learn the methodologies. One kid put in the chat, "I'm Bill, I'm 12, I'm not sure I can read the dissent." And I said, I know you can. And I'm really struck by how, starting at a very early age, people can understand the differences between these methodologies, and that
Do your kids
determines.
come back and say, "Daddy, are you an originalist?" Is that
my
is that
my
like a
my kids have given up on this long ago, and we don't I don't bore them with these debates
we
anymore.
don't talk the Constitution over breakfast anymore.
Absolutely, we don't play with the kids at home, exactly. At least in regard to the Constitution. And that's what will determine a lot of this. And of course, Justice Gorsuch's textualism and Justice Barrett's interest in what she calls liquidation, which is whether practice over a period of time might trump the original understanding, are going to be really important in determining how they come down in some of these cases. And the broadly pragmatic spirit of Chief Justice Roberts and Justice Kavanaugh will also be key. So that's why at the Constitution Center, we always insist we're going to debate these issues in constitutional and not political terms. And don't assume it's all politics. Just to completely reduce the Supreme Court to partisan politics doesn't accurately capture the way the court decides certainly the overwhelming majority of cases, if not all of them. And you really do have to geek out on text, history, structure, on the individual justices, on their methodologies. Justice Breyer, who's our co-chair, is asked in Zooms all the time, isn't it all politics? And he says it's not. It might be political philosophy. In other words, if a justice is a Jeffersonian strict constructionist or a Hamiltonian liberal constructionist, that might determine their views, or if they're broadly a free market libertarian or a socialist, that might determine things. But never, Justice Breyer says, a desire to help this or that president because of their partisan allegiance. So it's a subtle distinction, but as we all know when we studied this, constitutional law is a subtle blend of history and politics and pragmatism. That's what makes it so exciting to study, but it also makes it necessary to really dig in before you can reach a conclusion about how things are going to turn out.